My name is Emre Turkut and I work as a postdoctoral researcher at Hurt School Center for Fundamental Rights. So the question is there an effective system of preventing and monitoring torture or mistreatment for people held in detention? If yes, how does it function in reality? And if not, can we speak of an organized impunity in Turkey? Now, in the context of international law, we define impunity as the failure or the impossibility of bringing the perpetrators of serious human rights violations to account and justice. And in 1982, the military rule imposed a constitution on the country, which is the current constitution of Turkey, but they gave precedence to their interests over individual liberties. For example, a provisional article in that constitution provided full immunity to the leaders of the military coup as well as military state officials from any form of prosecution. For example, Turkey adopted a brand new penal code and code of criminal procedure in 2005, definitely with greater safeguards in the field of pre-trial detention because it reduced the detention period, so on and so forth. But as we argue in the report, these positive steps served nothing more than a band-aid on prevailing impunity problems. An attempted coup took place in Turkey, and that plunged the country to a national state of emergency. And Turkey, in its aftermath, derogated from a wide range of rights under the European Convention and International Covenant on Civil and Political Rights. For example, one of the very first emergency decrees in July 2016 authorized detention without access to a judge for 30 days. So Turkish government wanted to arrest and detain people first, and then they decided to collect evidence. Now, in the report, we comprehensively identify 5 factors that cumulatively ensure and reinforce the patterns of impunity in Turkey. And one such factor or root cause is the gaps in the Turkish legal structure. Turkish government adopted a legislation which gave a de facto impunity to state security forces for the alleged crimes took place in 2015 and 2016. So if you remember that period in the aftermath of the July 2015 elections, Turkey adopted an anti-terrorism policy which was very reminiscent of the 1990s. So the Turkish government and the anti-terrorism operations killed many Kurdish civilians and basically destructed the towns to the ground. And a number of emergency decrees adopted in the aftermath of 2016 attempted coup also, kind of brought further complication to this field. 2 emergency decrees adopted impunity clauses to state officials, to both state officials and civilians who took steps or measures to suppress the attempted coup, right? So we extensively deal with it in the report. But the point is, this has blocked the ways for accountability for many massive human rights violations, for accountability in the 2016 coup period. The Turkish main opposition party, CHP, took these 2 impunity clauses to the Turkish Constitutional Court, but Turkish Constitutional Court rejected to rule on this, on the unconstitutionality of these impunity clauses. Second factor we identified is the political rhetoric, both downplaying the scope of the impunity problem in Turkey as well as reinforcing patterns of impunity. The third factor that we have identified is the lack of political will to hold state officials accountable. A report by Ankara Bar Association, which is an association very critical of the government, very critical of Turkish government's authoritarian policies, as well as many other reports by different human rights institutions in Turkey, provided clear evidence of torture of these individuals, including stripping people naked, beatings, threats of being raped with batons. But Turkish authorities did not take any step, any meaningful step to address and prosecute these violations. And in August 2020, Ankara Chief Public Prosecutor Office issued a non-prosecution decision into these complaints, into these very big, very credible complaints. Fourth factor is the ineffective and delayed investigations by prosecutors. There have been over 1,000 criminal complaints, and over 90% of them are not investigated at all. So out of the 10% that finally reaches the trial stage, only a handful of imprisonment decisions is issued. So the ratio stands around 1%, perhaps less than 1%. So there is clear unwillingness on the part of Turkish prosecutors to investigate these serious claims of torture and eventually hold perpetrators to account. Final factor that we have identified is the, to say the least, complicit judiciary in Turkey. Now, the judiciary should act as a remedy against human rights abuses, but unfortunately, the opposite is happening in Turkey. Judiciary itself is responsible for a series of abuses. There is no effective preventive or sanctioning mechanism towards acts of torture and ill treatment in Turkey. The Turkish authorities show no willingness to prosecute these allegations and hold perpetrators accountable. And add to that, perhaps more importantly, the independence of the Turkish judiciary cannot be trusted anymore. So the findings of our report clearly show the organized, institutionalized, and entrenched impunity problem in Turkey. And we regrettably came to the conclusion that the practice of impunity has virtually become the norm for serious human rights violations committed by state officials. Now,